Today, our guest is Jack Cook. Jack is an experienced litigator and a talented trial lawyer and partner at Morgan & Morgan. Jack previously worked defense, but now Jack has a passion for representing injured patients and their families. He has won several multi-million-dollar verdicts on behalf of his clients. Jack has been recognized numerous times and presented with numerous awards, among which recently was recognized by the Daily Business Review and by the American Lawyer magazine. He's also a U.S. Marine Corps veteran. We are honored to have you on our show.
Great to be here.
What's easy to tell just by following you on your LinkedIn page is how passionate you are about your work in medical malpractice. Can you tell us a bit about how and why you made the transition to plaintiff work from defense?
Yeah, great to be here. A lot of passion for this area of law, but I think that a lot of it comes with an initial passion for healthcare and the healthcare industry. I always joke tongue in cheek that this is just my way of appeasing my Jewish mother for not becoming a doctor. I say, hey, at least I'm helping doctors become better doctors and hospitals keep better doctors and nurses. My background was in personal injury plaintiffs. I eventually linked up with a very good healthcare lawyer who does a lot of transactional healthcare law. So got to really learn the healthcare industry. And then I did medical malpractice defense for him and got to learn the trial stuff and everything. And just the patient advocacy, that whole thing that brought me into this field initially, which was helping people and helping the David's versus the Goliath, led me to flip back over to the plaintiff side. And I've honestly, in my career, I've gone back at one point and done a little bit of defense, come back here and do plaintiffs. And I feel we can do that in this medical malpractice, nursing negligence, birth injury setting, because all of the claims really need to be evaluated from a standard of care standpoint by qualified medical personnel like yourself. But that's how I got into it. And I haven't looked back. I've loved it ever since.
Have you used medical providers behind the scenes to help with your cases?
Absolutely. What I encourage is getting those people involved early in the case. A lot of lawyers turn down cases before they ever call or retain either a legal nurse consultant, or some people even use a local doctor anonymously. As much as we pride ourselves in knowing the medicine, we're not doctors, we're not nurses. So it's extremely important to have someone that's got clinical experience, because we have a lawyer hat on and we have the lawyer brain on. And that helps the clinical side of things because we get that cause and effect a little bit more. But the minutia of the medicine and what really happens, fly on the wall type of stuff, you're only going to get that by talking to a clinician who's been in the trench, who can say, you know what, in reality, this is likely what really happened because I've been in that situation. And as outrageous as it sounds, that stuff unfortunately happens. So, yeah, use those people a lot, try to get them involved as early as we can. And I really pride myself in using them throughout the case. I want them to be active partners in helping us try to bring this thing to a resolution.
Yeah, I had a case just the other day where one of our nurse practitioners got a call from an attorney who was asking whether or not there may be some liability in a surgical case. I jumped on that call with her, and he was saying there was a foreign body left in a surgical scenario where there was some bowel obstruction that occurred. And what tipped off the nurse practitioner was that the attorney mentioned that what was left inside the body was blue. And I'm a nurse practitioner myself, but I'm not a surgical nurse practitioner. And so it was just that little bit of a nuanced detail that had the nurse practitioner, who is a surgical nurse practitioner, wait a minute, it was blue? Because if it was blue, and then she went down this entire road about why the fact that it was blue was critical to establishing whether it was a standard of care violation that it was left in the body. I couldn't even recreate what it was that she talked about, but it was so interesting to me, and my jaw was left on the ground, as it usually is in conversations with my colleagues on the phone with attorneys, that these little nuanced things, I'm a nurse practitioner myself, but I don't know all of the nuanced things. So for you, how does that make a difference to you to get a specialist involved as opposed to just a go-to?
There's a lot of consultants out there. They're very smart people and they've done a great job of learning areas of medicine and nursing that are not their own. But at the end of the day, it's not their area of medicine. Probably don't have that real world clinical experience. Probably never had the chance to say, let me test my gut on this and see if it's this or it's that. So you bring up an excellent point. about getting to those specialists who can make those determinations where others may not.
If you have the right consulting expert, they're gonna help you to build the narrative prior to you going out and retaining that testifying expert so that you can ask the right questions, so that you can articulate the question that's going to get that same narrative to come out of that testifying expert on the stand and is going to build up your evidence in the courtroom through their testimony. And you have to get that through questions.
Yeah, absolutely. As an attorney, if you know the medicine well enough, you can get on the line with some of these experts and you can have that debate. But if you don't know the medicine good enough, that's another thing. Every single medical malpractice case that's in existence right now in this country, that's in litigation or it's in some form of claim, has one thing in common, that there are qualified experts on opposite sides saying the opposite thing. How much of a mess is medicine that in all these tens of thousands of instances, the qualified people that are supposed to know what they're talking about can't agree on what the standard of care is or what was the contributing causes of this outcome. Number one, medicine science. I know that there's a lot of people that practice medicine who will tell you that there's an art to it as well. The jury doesn't see medicine as an art. They just don't. And if you start talking about medicine like it's an art in front of a jury, it's going to scare them because we want a scientist taking care of us, not an artist. It is science and it is debatable.
To me, what reconciles that is that it is a network of algorithms. It's this enormous algorithmic network. An algorithm is math, an algorithm is science. But because there's so many nuances and branches to the algorithm, some people might describe that as an art because you can go just slightly this way and that way down the algorithm.
Two
Right.
and two equals four. No other way we can add that one up, right? I always tell my experts don't go into the art thing because jury members just don't want to think that you're going all Picasso on them. Artistic means lots of discretion, right? We've all seen what constitutes art. There's a lot of people that see art and say, wait a minute, that cost $10 million. Right? My kid can do that. But science, a little bit more fixed, a little bit more about rules. And what scares me is the fact that so many of those cases, just like the one you mentioned, can hang on a teeny tiny, minute detail. So that's it. One little fact in the case that takes that case and turns it. And don't expect that fact to be sitting there on the surface. It usually is something that's said, maybe not in the meat of the op report, but in the bottom of the op report. And so if you're taking on a case and you're evaluating whether there's potential negligence, is there any justification for not having someone who's qualified to look at every line and every page for that one thing that can hang the whole case on? When I first started doing this stuff, I got a little tip from someone. And that is when you call your experts, have your nurse consultant on the line with you, not just a translator, an influencer. We're going to debate here. We're not just here to say, oh, doctor, what did you see? This is science and it's debatable. And here's a kind of key to that for anyone listening that does any of this type of consulting. This is where you can really help the attorneys and how the attorneys can help themselves. You have to constantly remind these experts about what is the burden of proof. Our burden of proof in most jurisdictions and instances, we're only required to prove every fact by the greater weight of the evidence. Let's put it in math, 51%. Is there a 51% chance that this constellation of facts means that the standard of care was violated? Is there a 51% chance that this deviation from the standard was a substantial contributing cause to these injuries and their deaths? When you think about that, it does not sound like that high of a burden. And it's not because it's the lowest burden for anything adversarial. If you're in a criminal case, you're trying to prove your case beyond a reasonable doubt. That's 99% sure. If you're having to prove your case by clear and convincing evidence, that's 75%. We're way down here, doc. So I'm asking you, is there a 51% chance that our version of events is the right one? And so I always say to those doctors, as long as we can put this high up on the differential, that's going to satisfy that 51%. So let's not pretend like we need 95% certainty here or even 75% certainty, right?
Yeah, if you can just bring a certain condition a little higher on that differential, or it should have been higher than what the treating provider put it at. And sometimes it's not about whether or not that condition is likely to have been the case, but if it's a highly dangerous condition,
Oh, yeah.
and even though it may be rare or even though it may be unlikely statistically, if it's easy to rule out, then it would be standard of care to just go ahead and do the test. It's so simple to rule that out, and the risk of being wrong about it is just too high. The stakes matter. There's more than just statistics and likelihood of these conditions, but what plays into that algorithm is the risk of whether these conditions exist or not, and how dangerous is that for the patient.
That's an absolutely excellent point because these cases, as they're all different, they're all snowflakes, but certainly there's buckets that they all fit into, right? And that's a classic bucket. Guy that comes in with the PE signs and symptoms. But we automatically just say, we're just gonna hope that this isn't a PE and just start working our way down the list and start treating for things like pneumonia, right? So you're not ordering the D dimer, you're not ordering the studies. And it's a very common fact pattern. When I was in the service, we would do this very advanced kind of briefing. I was part of a unit that would get a warning order and we would float around the Mediterranean. And essentially, there was a fixed amount of hours, very short window, maybe 6 to 8 hours, that once we got orders, we had to have boots on the ground. Specialized missions like evacuating an embassy or reinforcing an embassy or rescuing a downed pilot or boarding a vessel full of weapons, very specialized missions. And so the idea was our proximity and the specialty of the unit was you get the orders, you're there in 6 hours. So we'd always do these debriefings, and the things you'd pay attention to the most is what the military intelligence guys would tell you, because here they're giving you, based upon their intelligence, what they know, what they've seen, what you're going to encounter when you get there. And they break it down into two separate groups. Here is most likely what you're going to encounter, and here is potentially the most dangerous and deadly thing you will encounter. So unlikely as it is, we have intelligence that this very dangerous and deadly thing, something that would appear and basically take mission priority over everything else because of its threat to just blow everything up. That's how that works in the exact same setting. When you're formulating that, the standard of care in many situations requires you to start working your way through the things that are the most deadly and the most dangerous before you start going to these other things and ruling them out. Before you start saying that maybe that chest pain is musculoskeletal, we're doing an EKG. We're not assuming that just because the guy came in and said, I've got the shortness of breath and I'm sweating like a pig and my blood pressure's through the roof. I think I might have just did a couple extra bench presses in the gym the other day. That would be below the standard of care just to say, well, this sounds like musculoskeletal to me. Get him off the monitors and let's just give him some Bengay and a couple Tylenol. Excellent point about that differential thing. And that's where you guys come in so very handy because we can only see what's in front of us. And what we can't see is what's left out of those records. That is so big. So if there's things missing on that differential list, we rely on that heavily. And I've made many a case by a nurse consultant telling me, hey, they didn't consider this one thing, and that's what this was. And lo and behold, I start sending that to the experts, and the experts go, that's what that was. And I say to that nurse consultant, you're a
Yeah.
genius.
We had a case recently where the go-to physician had already done the behind the scenes look, and then our consultant was brought in, quote unquote, just for a chronology. Please don't give us your opinion. The patient had come in with COPD exacerbation, and the attorney's theory was that they had over oxygenated the patient and given him way too much oxygen. She looked at the records and she noticed that there was an ER lab drawn that showed a TSH of 53, upper limits of 4, criticals 10 plus. It was hypothyroidism to the degree of what's called myxedema coma, which is a misnomer. It wasn't an actual coma, but the literature says actually does exacerbate CO2 retaining COPD. What they knew about this patient in the ER was that she had a thyroidectomy and she had been non-compliant with her medications, including her thyroid medicine at home. She has no thyroid function and she's not on
Right.
any medications to replace that. They should have known, and they did do a TSH, but no one looked at it. The physician that looked at the case before my nurse practitioner came in missed that. And that attorney saw the domino, but he missed the domino before it. And so My nurse practitioner called the attorney and said, "Did you get an endocrinologist on this case by any chance?" And he said, "No, why?" And she said, "The TSH is not really compatible with life." So he was able to then take that piece of information that we taught him and say to the physician who was reviewing the case, "What do you think about this TSH?" But if you don't have that original consultant looking at the case and
Oh,
giving
yeah.
the narrative, you can't take that question and
That expert would have never picked up on that.
no, it was buried
Okay.
among all these other things, and he was given a narrative by the attorney that he was trying to corroborate possibly some nurse, maybe a neighbor nurse or a friend nurse, or maybe a daughter nurse or something said, "Why was mom on oxygen? She has COPD. That must have killed her." And then they brought that story, and this happens so often, they brought that story to the attorney, and that kind of led people down the wrong path. He wasn't approaching it with an open
I'm
mind.
telling you, that's the ninja kind of function here. So understanding that in communication, add into that having a consultant on the line that knows the medicine, that's gonna also have a chilling effect for that doctor because a lot of these lawyers just rely on what the experts tell them. But I get the sense sometime that my expert really didn't go through everything with a fine tooth comb.
Yeah.
I get the sense they skimmed over things. That's why I'm sometimes reluctant to give experts a summary that I get from a nurse consultant. Now, sometimes I like that, sometimes I don't. And you're right. All of this has to happen before we're ever putting out experts out there to give sworn testimony. This is the stuff that happens well before that, so that by the time you get to that point, you've got a pretty strong wall built in your case.
I've done some lectures and courses to nurses about how to avoid liability in their documentation. If you can very clearly lay out your rationale for doing certain things and not doing certain things, then even if something goes wrong, if your rationale is solid, you might be able to have a lot less repercussions from that. But the other way around, if you fail to list exactly why you chose to not do this test or chose to do that test, you're going to have a hard time answering for that.
Yeah, that's where the good nurse consultant or medical consultant on your case that is willing to put on the x-ray glasses and look in those records. I really do have respect for the healthcare industry and anyone that participates in it. I'll be the first one to say that it's unfair because I make mistakes, but they don't kill patients. If my mistakes did kill people or did severely injure people, I can see how there would be a lot more need for accountability there, but I could probably count on one hand doctors, nurses, mid-levels, NPs that I have ever prosecuted one of these cases against, where I would say that person doesn't belong practicing medicine. They should be done with this. We are not going to be trying to prove that this is a bad doctor or a bad nurse because we will lose that case because it is not true. This is a good doctor or a good nurse or a good MP or a good PA who made a mistake,
Yeah,
you
and
know?
this patient needs and deserves compensation for something that shouldn't have happened.
Yeah.
That's a really important distinction. I think a lot of healthcare providers that get notified that they're being sued, they have this assumption that their entire livelihood is at risk. And sadly, what that causes some of them to do is in a panic to go and change the records and go back to that patient, look at what they wrote, maybe sneak in a few more sentences here and there, whether it's in the margins with a pen or whether it's on the electronic medical record and trying to slip that one by. Do you have examples in your practice where that has been to their detriment?
Oh, yeah. Absolutely. And I'm getting a great opportunity coming up here, and I'm so honored. I'm going to be speaking at AWON in June, their national convention down in New Orleans. And that's the nursing organization for obstetrical and neonatal nurses who every week are in the crosshairs of my cases. And the entire blast of this presentation is please come and hear from me so you never have to see me across the table from you. Because, you know, nurses just they get caught up in this. They honest to goodness do. I have so many examples, and I wish that in those moments that there was just the focus on recording down what accurately happened, and there would be a lot of saving grace. The nurses always have to remember that almost all these cases are going to involve something with that doctor, something this, but there's going to be that component of did this nurse communicate everything to this doctor? And did the nurse use that R in SPAR? Where was the nursing recommendation? Where was the request for orders? These cases come up, and maybe it's the hospital, maybe it's their risk managers, maybe it's their lawyers, or maybe it's just the nurses on their own who decide, I'm going to go in this deposition and act like a robot who doesn't have nursing discretion. I couldn't have done anything. I'm standing around waiting for a doctor to tell me what to do. Not true. Any good nurse knows that's not true. Nurses are absolute advocates. They have the absolute ability to initiate those nursing challenges, make those recommendations. This is the stuff that saves patients' lives every single day that goes unnoticed and unwritten. Just defines why nurses are so important in this process. They are the frontline soldiers here, bedside. And you know this as a practitioner, how reliant you can be on them being there to communicate that information back to you. But in those moments, if your record keeping sounds self serving, if the proverbial crap has hit the fan and you take pen to paper and start trying to defend yourself right then and there, someone like me, someone like you, we're going to know that. We're going to see and say, now, wait a minute. And I've seen it. I've seen it so many times. When I see a brachial plexus case and I see a torn up brachial plexus, which really only happens when a doctor applies excessive traction on the baby's head to deliver them. And I see written in the notes, only applied the gentlest of traction, gentle traction applied. It's like they're stating out a standard of care that
Right,
they
something that
otherwise would not be stating.
exactly. Listing out all the steps of the sterile procedure when changing a dressing. I placed my sterile gloves on in this fashion. You don't document all that.
Patient ends up with MRSA and ends up with a contamination. But you're 100% right. And the EMR has made it harder to do. And that's just another cautionary thing. We're going to know any record that's been gone back into. When you are trained to do medical record keeping, you're told, you're educated, you know that these records can be looked at by a peer review committee, by the Department of Health, by the Joint Commission, and by attorneys like me. Don't you? And they all say yes. And so when they sit down and write a loaded self-serving record, that's not going to be hard for a good lawyer to exploit. You were worried. You were panicked. You were concerned. I've even had people on the stand admit that what they put in those notes was not true and say, why did you put it? And they said, because I was worried. I was scared. Extremely important point on that. Absolutely no one who is a healthcare provider should be coerced to do anything other than get in that chart and put down what honestly happened, even from a defend yourself standpoint. If you as a nurse feel like it just hit the fan, and you feel like this could be a liability situation, then at least get in the record and make sure that you're putting in there an accurate summary of what your care was, because your deposition in that case, that's 4 years from now. The patient is probably going to remember every bit of it because you were their only nurse. This was their only medical thing. How many other patients have you seen in 4 years? Thousands. So yeah, record keeping is probably about a third of all cases start with something in that record.
Do you have a go-to that helps with audit trails for you?
I really like to give those to my nurse consultants and ask them to do a deep dive and learn a little bit. So some of them actually have done great. Nowadays, if as an attorney, you're not ordering those audit logs and having your nurse consultants or somebody and having them looked at, then you're making a huge mistake.
Nurses have some extra intuition in looking at the electronic medical record because they know the ins and outs of what it looks like on the front end. And so on the back end, it's like looking at a tapestry behind the tapestry. You can't really see the picture, but if you know what that picture is on the front, you can figure out where things are, even though it looks a little messy. And I think that can be really helpful as well.
I order the Pyxis records. I order the Omnicell records. Like, why are those so important? Because they show the literal time that the medicine came out of the machine. So when I look at the orders, that can be altered. When I look at the MAR, that can have an amended date put on there. The MAR says that medication was administered at 2 o'clock, but it wasn't even drawn from the Pyxis until 2:45. So triangulating stuff like that. But I'd venture to say 25% of lawyers get those Pyxis and Omnicell records. or the PACS records off of radiology. I've busted people on that. I've busted stat studies not being read stat because it looks like it's being read stat. But when you pull the PACS up, the radiologist never even opened up the film until way down the line. Yeah, it's extremely important. It starts with just a recognition that there's just a lot of it out there. Those audit logs, they are so confusing. It doesn't look anything like how they enter that stuff in real time. And when I'm showing them records and depots, they're like, I've never seen this before. It's, these are your entries. They're like, yeah, but I didn't enter it in like this.
Yeah, it pulls things from all over, and that's disorienting sometimes for the testifying experts, especially physicians. They're used to looking in the very specific places that they go to get the information they need, and they don't really have to look through the mounds and mounds of records because most everything will populate right into their progress note. So that makes it really convenient for them. But at the end of the day, there's a lot of valuable information buried in things like Pyxis records and nursing notes and things like that that are deep in the records themselves that kind of get flipped past by the testifying experts, but can be very easily caught by a consulting expert.
Probably the one that confounds me the most, doing as much birth injury as I do, fetal heart monitoring strips. Probably 2 out of every 50 hospitals actually includes those within the chart. Other than that, they never leave the obstetrics department. So when you put in a request for your full, complete, every single record on me here, that will be fulfilled without ever giving you those fetal heart monitoring strips. So I send moms and I say, you need to get those as well. And you'd be surprised the things that they say. I got to a point where I told them, if they won't send them to you in writing, go there, ask for them. If they won't take them, don't get in a fight. Get the person's name, walk out to your car, pull out your phone, pull up a video yourself and say, this is the date, this is the time, just spoke to this person at that hospital, asked for the fetal heart monitoring strips, and they told me, and then fill in the blank with the excuses I heard. They don't exist. We don't keep them. We don't allow patients to have them. They're offsite in storage, whatever. I said, all you got to do is record that because I promise you, we will get them. And they're probably not going to be good for them, or else you'd have them by now. And when we flash forward years from now, when we're in trial, it will allow me to say, now, ladies and gentlemen, guess what? They didn't want mom to have these strips. They told her they didn't exist. But bad news for them, we got them. And you're going to get to see them. And guess what? You're going to see full well why they didn't want this mother to have them. Those fetal heart monitoring strips, that's it. That's how you evaluate a birth injury case. And really, that is probably the most important piece of evidence you've got. And that's not incorporated in their charts. Even when there's a compromise, they will be nowhere to be seen, but they're there. One of the things about having so many great consultants, the ones that really want to dig in there with you is they join you in that persistence. They join you in that passion because they want to get to the bottom of what happened too.
Yeah, they can call out those inaccuracies about what is and isn't retrievable and accessible and say, that
Yeah.
doesn't sound right to me. Because otherwise, going at it on your own, you might just go, I tried. I guess they just don't have those things.
Yeah, and it's just about being persistent and in doing what you guys do. Whenever I'm dealing with experts or consultants or anybody, can always tell I'm dealing with a sharp stick. When I hear back from them, I want to see more. Can you request this and that and this? I want to see this film and this study. It's like, hey, like this is someone that's trying to piece together the puzzle. And I like to hear it. Yes, we'll get you those things and get them looked at more. And one of the things that for anyone looking at these cases early to understand is we're really looking for questions here. There's still this missing component that you don't get to until you get people in the chair explaining why is that in the record? I went 2 years on a case thinking this lady applied fundal pressure in a shoulder dystocia situation, pushed on the mom's belly, causing the baby to become impacted because a nurse went in there and said it was this nurse that did it. When I'm deposing that nurse who had turned into an NP and a good one, I'm thinking to myself, halfway through this depo, I can't believe that this lady would have done fundal pressure. She's so sharp. She's smart. And then she tells me, wasn't me. I was 8 months pregnant. I wasn't doing fundal. Done. You want your conspiracy theory? All of a sudden, I'm saying, then who was it? Wasn't the nurse that recorded it because she told me I recorded it. I saw someone. So all of a sudden, that case turned into there was more people in this room that's on this record and that the hospital's telling us. And that case settled. That case resolved, but only by really exploiting that fact. From the moment that nurse said, "It wasn't me." And that's something you only found out a year and a half into litigation in a deposition. Otherwise would turn that case down or whatever they would do with it. Something that the consultants and experts should bear in mind. We pay the freight. We pay the expert costs, pay the consultation costs. We're not afraid to do that, to hold on to something to make sure that we're not missing something. That's the worst. The worst is to send anyone out the door saying, "We can't help you," only for them to pop up somewhere else and for them to say, "Well, guess what? We can help you." Should never feel guilty about billing us or charging us for that because we just want to make sure that we're helping as many people as we can and not missing something that goes out the door that we could have latched onto and helped. You think about that. You think about that. You think about how important what we do is. It saves lives. When I'm in a hospital, I am watching in wonder every safety measure that's happening. And some of those things I say to myself, I wonder if that little safety measure is in place. I wonder if that nurse is standing there checking what's on that infusion machine because this hospital has a policy that when we're administering a dangerous drug, then we're going to have a second nurse come in and validate it. Maybe that policy was born because of a case like this.
Exactly. Yeah.
So when we let a case go and don't prosecute where there was a deviation from the standard of care, we have not put a healthcare provider on notice of that mistake. And who knows, they might make it again. One of the things I love about doing what I do, whether I'm right, wrong, win, lose, I don't care. Good doctors and good nurses, they listen. And when you call them out, even if it's just, "Hey, I think I might have done the right thing," they're going to listen to you. They're going to listen. And the next time that set of facts comes in front of them, I don't care if they want to admit it or not, they're going to treat the situation differently and more careful. So for me, it's like this personal thing. I don't like missing out because when we do not do our job and meticulously find those breaches, that literally could cost people their life. It's not about money in the bank account. There's a doctor or nurse out there that needs some corrective action to help make them a better provider, and that will help save lives. I might have the case where the mistake didn't kill the patient, but it resulted in them having to go have another surgery or another hospitalization. A lot of lawyers aren't going to like that case because they're going to say they're essentially back to normal and they lost some time. But in my mind, it's like it could have killed this patient.
And it could kill someone else if it happens again.
100%. And even though that's not actionable, there's nothing to go on a trial and say, "Hey, this could
Of
have killed a
course.
patient," even though it didn't hurt them. It did cause them to have this, that, and the other. In the back of my mind, in the
Yeah.
back of the patient's mind, they know that what they're doing could prevent this from happening again.
Yeah. The medical malpractice industry as a whole is a refiner's fire for the healthcare industry to ensure that all of the imperfections are one by one burnt out of the system so that all of us who at one point in our life or another are going to wind up in a stretcher, in an ER or in a hospital bed, that it's as safe as possible. Every time there is something that occurs in a hospital, it has the potential to leave a legacy if they take action, take accountability and say, what can we do better to prevent this from happening again? And so ultimately, it really does refine the healthcare
And,
industry.
and the mistakes aren't going anywhere. Even the best out there is going to do their best to minimize these things. Fortunately, most medical and nursing errors do not result in harm to a patient, but you've got these harrowing statistics out there. You've got statistics out there that say that less than 20% of these things are reported or elevated or raised. When a 75-year-old dies on the table during open heart surgery, it's sad, but a lot of people aren't asking questions. They're saying, well, he was 75 going through a quadruple bypass. But what if there was a medical error in there? What if there was a preventable mistake in there? It's not like people are running down the hole raising those issues. They're not. Sometimes they do. I got to tell you, a lot of my birth injury cases start with a mom or dad coming to me saying that a nurse whispered in their ear, "You need to go get a lawyer." And every time I hear that, it makes me smile. I get what the nurse did. I'm okay that they didn't do anything officially about it, but at least that's someone that's telling them, I'm seeing something here that needs to be looked into.
Our episode 3, we brought on a nurse that was actually a nurse that took care of the baby in the NICU following an injury.
Wow.
There was a baby that was injured while she was caring for the baby on the night shift, started flipping through the records and was like, "Oh my word." It's an interesting story. You should listen to our episode 3.
There's no gold medals in what I do. I can't give my clients what they want, need, or deserve. It's just impossible because I've never represented anyone in a medical malpractice, and especially not a birth injury case, who wouldn't gladly give back every penny I've ever won them, whether it's thousands, tens, hundreds, millions, or tens of millions, to have their life back or their child back. The best we can do here is a silver medal. That's the best we can do. We can repair what can be repaired. We can replace what can be replaced. But there's some things that will never be able to be repaired and they will not be able to be replaced. And I wish we could. I even tell juries what we want you to do, you can't do. I want you to go back there in that deliberations rooms and put all your heads together and build a time machine so we can go back in time and tell this doctor, this nurse, this NP, slow down, turn around, go back, look again, consider again. But they can't give us that. And we're forced to ask for this monetary compensation, as uncomfortable as it is. And yes, it's easy to sit there and say that someone that's got cerebral palsy or something, this is going to be what kind of healthcare they're going to need for the rest of their life. When you start asking about the monetary value for the pain and their suffering and the pain and suffering of their mom and their dad, these parents get asked some unfair questions, right? Hey, just because your child's in that condition doesn't mean you love them any less, does it? Of course, we know that's not true. But you know what it means in reality? It means that child does love them a little less because some of these kids have no concept of what love is. That's how far gone they are. For a parent to be saddled with that, with all the optimism in the world, knowing I will not be able to hear my child ever utter the words, I love you. It's beyond the pale sometimes to imagine.
Yeah.
You can remember Back to the Future 2 when Marty went to the future with the doc and Marty was trying to get the doc to buy the sports almanac and said, we should take this back and make all the bets and make a bunch of money. The doc said, he can't do that. It'll change time. And old Biff hears that and takes the book, goes back to 1955 and gives his younger self the book, tells him, bet on all the stuff. And in trial, I draw this out on the board like Doc Brown does. When they get back to 1985, the entire world is different. Now Biff's in charge of everything. Marty's father's been murdered. Biff's now married to Marty's mother, who now has a pair of fake boobs. The doc's been committed. And Marty finds the doc and says, what happened? And he said, when Biff went back to 1955 and did this one little thing, created an alternative timeline. And we are now on this alternative timeline, 1985. So I draw that out for a jury and I say, that is why we are here. Because if we take away this breach of the standard of care, then we are on this timeline right here and we never are off of it. And we are here to find out what would this have been had this not happened. Then that's a child that's running around, climbing the monkey bars, going to school, just like I have in my kids, other people have in their kids. That's the world that would have been but for this negligence. Do we imagine that these parents would be less stressed out if they only had to deal what I had to deal with? A 9-year-old who only ate chicken nuggets and pizza? That's my problem. My problem with my kid is that she only eats 4 things and I can't get her to expand her palate. But there's other people that are suctioning their babies every 10 minutes so they don't aspirate to death, right? Instant perspective. That is really why it is just so important to know what is that removable thing. That's how important it is. And like you brought up, it could be a single thing. Normally it's a communication error, constellation of problems, but it really could be a single point of data that if that was removed and didn't happen, or if something was done that wasn't.
Yeah. Well, a lot of times there's layers and layers of safety nets built in, and it is really sad when something falls through every single net down the line and lands in this kind of scenario. But the other safety nets wouldn't have failed because they wouldn't have been necessary in the first place if this one thing hadn't happened. Hearing you talk about your plaintiffs and what their parents go through and things like that. As parents of children with such intense needs, that's just how it is. For a while after she was born, I would look at other children her age and I would look at a 4-year-old when she was 4 and I would say, well, that's what Lucy would be doing now. And it would choke me up a little bit. And then when I saw a 6-year-old and she was 6, but at a certain point, I just stopped doing that and I just don't anymore. And so I don't really ever think about that other trajectory anymore. And maybe it's just because it just became too painful.
I would say probably yes, but also I see the evolutionary process with parents all the time. And there's so much positivity that comes out of what I do. The negativity sucks, but I get to see these parents communicate with children and convey the same love that I convey to mine, communicate love the same way that I communicate to my kids. And it just, there's no difference. There's no disparity. It's like that is their baby, will always be their baby, just like my children will always be mine. It made sense to me when my kids were born. Before that, it didn't make a lot of sense. When my kids were born, and anyone that has kids, life just became pretty easy when it comes down to questions like, what's most important to you? What's your life goal? You even get a new life expectancy goal. I don't care when I die. I just don't want to bury a child. Just don't want to have to see one of my kids go before me. So you get to see so much positivity of it. But I think at some point in time, a lot of parents just do what probably comes later to some of us parents in life, which is just the understanding of this is my connection. This is my journey. This is our adventure and our experience. And you just get to see how love is something that is conveyed in such different ways, but no better way that we convey love to any other human being than to take care of them. That's the best thing we can do. The best thing we can do is to care for somebody. So you get these situations like the one you're in. You actually have those moments of that pure and true love a lot more often than I do. And it's remarkable. They are connected to their children in the same degree of intensity that I'm connected to mine. And it's just, it really is heartwarming to see.
I love that you brought that up about just getting engaged in your plaintiffs' lives and getting to know them. For our attorney listeners, how does that help you at trial? What do you think that tip of getting to know your plaintiffs on that level, what has that done for you?
I love those moments when I get to see them. I visit every client and go in their home so I can see it happen in their element. And it emboldens me. It emboldens me so much. I'm seeing that child through their eyes. And even though some of them we don't even know what degree they're comprehending, I can see a parent that knows in their heart that child loves them. And it's a real thing. It's really cool. I just got out of a trial where the wife was 87 years old. Her 91-year-old husband, who was the plaintiff in that case, was so infirm he couldn't come to trial. She's our one and only eyewitness. A lot of attorneys would say, I'm not going to put an 87-year-old lady on the stand. But see, I met this lady. I broke bread with this lady. I had several meals with her. I visited their home and I got to learn her. And I got to know that I would be able to put her up on that stand and have one of those great conversations like we just did over a 2-hour breakfast and get the good stuff. And we did it. And she carried the case, but only something that happened because I took off the suit, went into her home turf. My office is intimidating. There's books everywhere and mahogany everywhere and statues everywhere. And in her home field to her comfort level, and made that connection, saw things in their own, got to really know what type of person I'm dealing with. And we were able to get on that stand and do the dance and got an amazing result in that case, which I give her so much credit for because she had to be there and bring this guy to life because we had to tell the jury he can't even be here. You're not even going to see this guy. You're not even going to meet this guy who we're asking to give millions of dollars to. That degree of connecting with your clients, it's extremely important. This is a complex process and there's two different approaches to it. There are some lawyers that really want their clients to play that passive role They're just trying not to give them the anxiety. They're trying not to give them the stress. They're trying not to bring them into a situation that can be fluctuating and ever changing. I had a conversation with a client. She's like, last time I talked to you on the phone, you seemed all very gung ho about my case. Now you're on there telling me about all these weaknesses in the case. And I said, yeah. And I apologize for that, but that's the way that it works. Sometimes good things happen and the case gains strength. Other times things happen and the case loses strength. But that's my practice, is to be completely transparent, because you're the one that's going to have to make decisions in this case. I even like to sometimes put my clients in touch with my consultants. They've got questions they want to ask the patient. I put them in touch with them.
Right.
Absolutely.
The algorithmic nature of what we do. Again, not an art, but a very complex algorithm. Like, I could, as a consultant, ask you questions that you can go take to your plaintiff, but then those answers are going to create more questions. And this sort of back and forth with the attorney as the liaison isn't always the most efficient way to do things. Sometimes it is more efficient to just put the consultant on the phone with the plaintiff and just maybe a three-way call or something, to where we can move through that algorithm a lot quicker because we get those answers, and those answers generate new and different questions depending on the answers.
I do that all the time. I do that all the time, especially when I have got a very active and inquisitive patient, and they love it. They love it because they like to be part of the, and look, I need them. They were there. They don't know what they saw. They don't know what they heard. A lot of them don't know that what they saw and what they heard was important. Some of them think that was such a minor detail, not understanding that was a very key detail. But it takes people like you and me fishing that out of them. So, yeah, I do that all the time and put them in touch with the consultants.
That's a great tip. This has been a really fascinating conversation. You brought up some really great points. I really appreciate you coming on, and I would love to have you back on sometime.
I really appreciate it. Thank you so much. It's very engaging. And this is just such a great effort, because a lot of the information I've heard on, other episodes and everything, these are nuggets. This is it. This is the brass tacks of what makes it from any side of this. These are the bricks in the wall that you need to build a strong case, whether you're on either side. If you're not doing this stuff, then you can't really look your client in the eye and say you're using every tool in the bag.